Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. In a major development, the Supreme Court today directed implementation of a minimum one-third women's reservation in the posts of the Supreme Court Bar Association, henceforth including the coming elections. The court directed that one post of the office bearers of SCBA shall be exclusively reserved for women by turn and on a rotation basis. This exclusive women reservation will start with the coming 2024-25 elections, as the post of treasurer of SCBA shall be reserved for a woman candidate this time. The bench comprising Justices Suryakant and K.V. Vishwanathan clarified that this reservation will not preclude eligible women members from contesting for other posts. The court has directed the elections for the 2024-25 term to be held on 16th May. The counting of the votes shall commence on 18th and the results shall be declared on 19th May. The court noted that 8 resolutions seeking reforms in the eligibility conditions for candidates, changes in the admission fee, revision of the cap of 4 terms for member to hold an SCBA post, etc., had failed in the special general body meeting. However, the norms of the SCBA cannot remain static for decades and timely reforms are needed. Coming to an update from the Calcutta High Court on the matter related to Sandeshkhali violence. A division bench of Chief Justice T.S. Sivangnanam and Justice Hirannamai Bhattacharya had earlier entrusted the investigation into allegations of land grabbing and sexual assault to the SCBA and was perusing a report by the agency. Upon perusing the report, the bench noted that while things were progressing as directed, the state had been hesitant to share land records with the SCBA and directed for the same to be done expeditiously. It was stated by one of the PIL petitioners that victims were being threatened by local goons against revealing the details of the sexual violence to the SCBA. It was stated that there was no protection for them during the night time when they were vulnerable to being attacked. The High Court today directed the SCBA to evolve methods of confidence building among local women of Sandeshkhali who were victims of sexual assault in order to register their complaints. The bench also allowed a plea for intervention by the National Human Rights Commission to intervene in the matter. The Delhi High Court today disposed of a PIL to curb circulation of deepfake videos during the ongoing Lok Sabha polls. The PIL sought direction on the Election Commission of India to formulate guidelines for verification of video messages to weed out deepfake videos or for prohibiting the use of deepfake technologies in any media or mode of mass communication that may be employed for reaching out to voters after enforcement of the Model Code of Conduct and till the declaration of election results. The petitioner also cited certain recent examples of such videos making rounds on social media. The counsel appearing for the Election Commission told the court that any steps which are required to be taken in the matter shall be taken by it. The counsel further informed that FIRs had been filed on the criminal complaints lodged regarding the deepfake videos as mentioned in the PIL. He said that accounts in question had also been withheld by X platform. A division bench comprising Acting Chief Justice Manmohan and Justice Manmeet Pritam Singh Arora disposed of the PIL, observing that it could not pass a direction in the middle of the elections and that the Election Commission of India was not remediless and would act on the issue. The court also remarked that a dynamic order could be passed by the Election Commission, saying that all the links which have been retweeted will also be disabled. The Madras High Court has paved the way for a student with a special need of wearing adult diapers to attend the NEET undergraduate examinations wearing the diaper. The court was hearing the plea of a NEET aspirant who, after meeting with a burn accident, was taking treatment for a neurogenic bladder. The doctors had certified that the candidate had a lack of urine control and needed to wear a diaper continuously, which also had to be changed frequently. She had requested the authorities to permit her to write the exam wearing the diaper and to change it in between depending on her condition. Since there was no response, she approached the court. Justice G.R. Swaminathan observed that any candidate who was not necessarily suffering from any disability which is set out under the 2016 Act but otherwise had special requirements or had a biological condition was also entitled to reasonable accommodation. The court therefore allowed her request. The Delhi High Court today refused to entertain a PIL seeking a direction on Centre to constitute a legal education commission comprising of retired judges, law professors and lawyers to ascertain the feasibility of 4 years LLB course. The PIL was moved by an advocate who submitted that earlier there was a 3-year LLB course after 12th standard. The counsel appearing for the Bar Council of India told the court that the petitioner had filed a similar petition before the Supreme Court seeking to allow 3-year LLB degree course right after the 12th standard. However, the Apex Court refused to entertain his PIL and the same was withdrawn. A division bench comprising Acting Chief Justice Manmohan and Justice Manmeet Preetham Singh Arora remarked that it is not the court's domain to design courses and that the authorities would decide the issue. The bench said that the authorities were continuously reviewing the law courses and courts cannot go into their domain. As the court was inclined to dismiss the plea, the petitioner withdrew the same. And lastly, the Allahabad High Court has denied bail to Uttar Pradesh Member of Legislative Assembly Abbas Ansari in connection with the case alleging that his wife had been unrestrictedly visiting him in jail and he would use her mobile phones to threaten various persons, including the witnesses and officials who were connected with the prosecution. Ansari, an MLA from Mao Assembly, has been booked for various offences under the IPC, Prevention of Corruption Act and the Prisons Act. The allegations are further to the effect that his wife would frequently visit the jail without complying with the formalities and prescribed restrictions. It was alleged that Ansari was being provided all sorts of benefits during his incarceration for which the officials of the jail were paid both in cash and kind. It was also alleged that he was also planning to stage an escape from the jail with the help of his wife's driver and certain jail officials. Seeking bail in the case, Ansari argued before the High Court that no offence had been made against him and that a meaningful reading of the FIR would indicate that the allegations were primarily against his wife and another co-accused who have been granted bail. A bench of Justice Jaspreet Singh observed that considering Ansari's profile, background and family antecedents, the allegations against him may not be completely without substance, and thus his bail application was rejected. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.